So good morning everyone. So we are at the second day of our Guru Shishya revision for this week's Polity test. Okay. So one thing I must tell you before we start, actually we have to complete our Polity revision today. For that actually we have to cover maximum number of questions which are selected from like covering most of the topics of our syllabus. These questions would be a representative sample of most of the topics in the Polity syllabus. Okay. Tomorrow you will be having a current affairs session. Okay, that will be taken by another faculty. He will be taking like all the last year's current affairs which is related to the Polity subject, which can be like useful for the examination. Okay, so we will be moving very quickly because we have very limited time. So I expect everyone to participate equally, okay, from all the sides of this class, not only some people from here and there. Everybody, even though you know the answer or not, you have to respond. Okay, that's the way of improving your thought process. Okay, anyway in the exam you cannot keep on skipping the questions. You have to make some negatives, okay, but that negatives will be positive after some round of the test. So that to develop that thought process, you have to respond for each and every question actively. So tight your seat belts, will be moving very quickly. So let's start with the first question. Consider following statements. According to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months, even if he or she is not a member of legislature of that state. According to the Representation of People's Act 1951, a person convicted of a criminal offence and sentenced to imprisonment for 5 years is permanently disqualified from contesting an election even after his release from the prison. What about the first statement? True or false? Okay, how many for true? Okay, so I'll ask the remaining people why it is false. Okay, if they, okay, yeah, the statements once again, like for the remaining people and for everyone also, those who said true also listen once again and like brainstorm once again. I am not telling whether it is true or false. According to the Constitution of India, a person who is eligible to vote can be made a minister in a state for 6 months even if he or she is not a member of the legislature of that state. So like at what age a person can become a member of legislative assembly? 25, and the voting age is 18. So they are saying that at 18 years they can become this one, right? So whether that can be true, they must, like, even though like it is true that a person must reach the voting age, but he must reach the age of 25 to become the member. Okay, so that thing, that is the first statement. The second statement, according to the Representation of People's Act 1951, a person is getting convicted and he is getting convicted for a period of 5 years. They are telling that he is permanently disqualified. He can't like participate in the election in the lifetime. True or false? False. See, actually you have to deduct the statements in this way. Since I am explaining by emphasizing on some words, you may get a clue, okay, but in the exam hall you have to emphasize this. Okay, now this is the explanation. An individual who is not an MLA can become a minister if he gets himself elected to the state legislature within 6 months from the date of his appointment. That is true, okay, but however, while the voting age is at 18 years, a person can become an MLA after only after 25 years of age. So like a person cannot claim that I have reached the voting age, so I must be like getting a chance for becoming an MLA. He cannot claim that. Second thing, the convicted candidates, okay, if he is getting convicted for 5 years, for that period he may not contest. Okay, after that he can contest. I mean, he can contest the election. So that thing you should have in your mind. Next question. Nomination of members to the Rajya Sabha by the President was borrowed from Australian Constitution. Second statement, method of election of President was borrowed from Irish Constitution. Which of the following statements is or are correct? First statement, true or false? So which is the correct country? Second statement. See, actually the issue is we all study the borrowed features of Constitution, but the problem is that we always study the features from 1935 Act or US or UK like that. But there are some like elements that we often do not focus, like nomination of the members to the Rajya Sabha kind of thing, and such kind of elements actually we overlook, we don't like emphasize, but they ask from these questions, like they won't be asking like, yeah, I'll ask one more question, yeah, it's there in the next question, but what I'm saying is actually you go for the fringe statements, I mean the narrow statements, like don't every time look at the major sources like 1935 and Act and all. You should go for South African constitution, like you should go for Japanese constitution, like whatever constitutions are mentioned, like there may be only one provision which is taken from South African constitution or Japanese constitution, but they can ask that statement, okay. So, and from Ireland also actually there are like diverse elements which we have taken from Ireland. So you should have that thing in your mind while you study. So the next question, the concept of concurrent list and freedom of trade are derived from which constitution? Australian constitution. I'll show you one strategy, like so that you won't be forgetting, because there are multiple elements taken from multiple constitution. You just see this is like mostly clear for everyone, like Government of India Act of 1935, the basic structure we have taken from 1935 Act, okay. Then British constitution also, we know that we follow the parliamentary form of government. So the rule of law, the single citizenship, legislative procedure, mostly we have taken from the UK constitution, because they have created all this structure before they went. And US constitution, fundamental rights, independent judiciary and judicial review, and this is where we start confusing, like method of election of president was taken from which country? Method of election of president? Ireland. Here actually impeachment of president, okay. So you might get confused, okay. Both are talking about president, but one for selection and one for termination, okay. Then removal of Supreme Court and High Court judges. Actually we will go through these kind of very famous kind of statements, but removal of Supreme Court and High Court judges, impeachment of president, and in exam hall they may give like similar statements, like they will give the same elements from US constitution. First statement will be impeachment of the president is taken from US constitution. Second statement, removal of Supreme Court and High Court judges is also taken from US constitution. At that time we will start confusing. Both are talking about removal of two different people, and how can that be same from the same constitution? These kind of confusions will come, okay. So you should be very clear. And the post of vice president. Now here is another thing. Nomination of members to the Rajya Sabha is taken from which country? Ireland, right. And who is the ex officio chairman of Rajya Sabha? Vice president. So in the exam hall we will start thinking like something related to Rajya Sabha is taken from Ireland. So post of vice president will extrapolate to that kind of thinking. So in order to avoid that confusion, I am telling these kind of things. Now the other thing, see what is like, can you make a broad statement about Canadian constitution and Australian constitution, the nature of provisions we have taken from these sources? In Canadian constitution you see federation with a strong center, residuary powers with the center, appointment of state governors by the center, advisory jurisdiction of Supreme Court, everything related to some centralizing tendency, right? You should have that thing in your mind. So when you, even if you don't know the answer, but if the provision is like emphasizing something related to center, okay, that there is high chance that it is related to Canadian constitution. Second, Australian constitution, concurrent list, I mean sharing of subjects, freedom of trade and commerce, I mean between states. Then joint sitting of upper and lower house, it's also sharing of something, okay. So this kind of federalism kind of thing is taken from Australian constitution. So this is the way, like we should not mug up things, we should have a broad idea of things so that we can do elimination. And these are like a very simple kind of thing. French, like everybody knows these ideals are taken from France, and Russian we also know, like the ideal of justice and fundamental duties. Weimar constitution of Germany, suspension of like fundamental rights during emergency. You may just like have a link with the Hitler and all, like with emergency kind of stuff, okay, so that you can relate that with Germany. So and South African constitution. So there should not be any like confusion between like Irish constitution and South African constitution. This confusion will definitely come if you are not clear. Election of the members to the Rajya Sabha is taken from South Africa. Nomination of members to Rajya Sabha is taken from Ireland. So nobody should make this mistake, okay. Now next question, economic justice as one of the objectives of the Indian constitution is provided in preamble and fundamental rights, preamble and DPSP, fundamental rights and DPSP, none of the above. Preamble and? Very good. So, one sec, yeah. Economic justice is mentioned in the preamble. Like, see, we know that in preamble, justice, social, economic and political is mentioned. Okay. In DPSP, we have this kind of thing, like a social welfare kind of stuff is like given in DPSP. Securing a living wage, decent standard of living and kind of thing, promote the welfare of the people. Okay. So, economic justice is closely associated with these two provisions. Okay. So, we should relate in that way. With respect to the minority institutions, which of the following is correct? Read for yourself, so that if I am reading, I may emphasize on some words so that you will get a clue. I have taken the most confusing, twisting kind of stuff from most of the syllabus topic, so that you can get a fair idea about how they will confuse you. So, do not say the answer, please raise the hands. How many for option A? They are asking which of the following is correct. Option A, nobody. Option B, again nobody. Option C, okay. And option D, see, some people has not raised their hands. This is what I am telling. What, like, you guys will be skipping the questions in the exam hall. These are basic questions, though there is an element of confusion in this, but I am trying to make that confusion clear so that you won't face this confusion in the exam hall. But for that you have to actively participate. Okay. So, most of the people went for option C. Article 29 exclusively covers cultural rights of minorities and Article 30 covers educational rights of religious and linguistic minorities. So, what is the text of Article 29? Does it covers only minorities or all sections of the citizens? So, how can they say that it covers exclusively rights of minorities? Okay. So, you have overlooked that element. These kind of statements will come in the exam. This statement is actually wrong, where majority of you like made it, chose it as the correct option. So, the second, this is the way, even this you can expect this kind of questions in all the mock test and the original exam as well. You know, to confuse us and to make us tempt to choose this statement correct, what they have done is Article 30 covers education rights of, they made it like a plain and very simple straight away statement. Okay. So, we will be overlooking that. So, with this understanding we will be looking at this statement as well. Article 29 exclusively covers cultural rights of minorities. So, the twist is that in constitution it specifically says that Article 29 is for any sections of citizens. And what is the specialty for Article 30? It covers exclusively minorities. What all minorities? Religious and linguistic minorities. Even they can ask like Article 30 is for only for religious minorities or like only for linguistic minorities. Even in that way they can ask. Okay. So, what's wrong with the statement A? Like, why you guys like ignored it? Because that you like have no exception, then there can be no reasonable restriction kind of thing. Okay. So, this is why I purposefully selected these kind of questions as a representative sample of each of the syllabus topic. See, actually the unique feature of Article 29 is that it is an article with no exception. Okay. So, you know what is the text of Article 29? Protection of interest of minorities. So, though this is the major text, you read the definition. This article is intended to protect the interest of minority groups. They says like that. Then the expansion is this provides any sections of citizens. Okay, this is the text from the constitution. Any sections of citizens, not only minorities, though the broad heading is of minorities, but the text says this provides any sections of citizens residing in India having a distinct culture, language, script, I mean the cultural rights. Okay, the right to conserve their culture, language and script. So, that is for any sections of citizen. And this article is having no exception, no reasonable restriction. Like government can never say that, okay, because of these facts we are restricting your cultural rights. This cannot be done for Article 29. Now, the 30th, Article 30 is called Charter of Educational Rights. It provides the religious and linguistic minorities right to establish and administer education institutions of their choice. Clear? Okay. Right to vote and to be elected in India is a UPSC question. Constitutional right. you don't have any doubt about the legal right provision. Why? Okay, anyway it's not fundamental right, everybody knows that. It's not a natural right. What is natural right? Being born as a human, we should be able to right to vote, like that's not possible. So somebody should be the citizen of country, there are other conditions to be able to get that right to vote. And constitutional right, definitely it is said in the constitution, okay. Now you should not have a doubt about the legal right, because if it is a legal right, there should be a law stating that everybody should be everybody should vote, okay. We don't have any such laws, okay. So it's a constitutional right. Which article says about this? So article 326 of the constitution provides that elections to the House of the People and the Legislative Assembly every state shall be based on adult suffrage, and the condition is that a person should not be less than 18 years of age. So there can be another question from this thing. They can say that from the beginning of constitution, a person having an age of 18 was given the right to vote. Is that true? What's the issue with that? 21. So it is only by 1988 our voting age got reduced from 21 to 18, okay. That's a constitutional amendment. You should be mindful of this fact, okay. They can give a plain statement, we won't be focusing on the part that from the beginning of the constitution kind of stuff. We will be focusing on the remaining thing, okay. So every word, if the statement is having two parts, we will be reading maybe one part and we will be automatically thinking that the next part is true. So the first part they will be making it very easy, so that our eyes will stick to that and we will decide that okay, this statement is correct, we will go for checking other statements, okay. But the second part, there may be one word which make that statement false, okay. So you should be cautious about that. Now consider the following statements. Article 37, okay, you can read for yourself. Think that you are writing this exam, okay. In a few days, 3 days or 4 days, you are going to write the exam. Think that if you say without thinking properly, if you decide on an answer, you are getting a negative mark. So you will be losing your hard and positive marks as well. So think twice or thrice. Okay, can we eliminate any statement here? Which one? Second statement. Okay, if you are eliminating second statement, you will be having two options remaining. I am not telling whether that is true or not, but for the people who eliminate second statement, two options will be remaining. So from that, what will be your decision? Why 3 is false? They are telling that actually whether it is naturalization of anything, they are telling that one person will not lose citizenship if he is doing things that is against our constitution, okay, against our government or thing, we will definitely lose the citizenship. Actually this statement could be easily eliminated, okay, for the very first site itself. So then we will directly reach the answer. That is one way. The second statement is also equally good for elimination. They are telling that in US also there is only one citizenship, okay. But why I said this statement should be first eliminated, because there may be people who won't be knowing that in US there are state citizenship as well, okay. That's a one step ahead. So if people are not clear with that fact, then also by eliminating this statement you can reach the answer, okay. So only in India, though we are also technically a federal country, we have only one citizenship, but US is the true federation. They are having dual citizenship. They are the citizens of America, USA, and they are the members of their, citizens of their respective states as well. So that is that question. Now, see, these are real-time UPSC questions. So have that seriousness when you read. Who all are there for option A? Very quick. No. Who all are there for option B? Option C? See, don't answer by looking at others, okay. You should have your individual answer, okay. Option D? Nobody. Okay. Did you have any confusion between option B and option C? No confusion. Why? Government is elected by the people and can be removed by them. Why no confusion in that? Yeah, because we are not a like direct democracy. Okay, we are having a representative group of people. Okay, so when this question was asked, many people got confused like between B and C. Okay, so people thought in the line that actually in the preamble we say that actually people are the source of power. So they thought in that angle. So one or other thing that we studied in the like long course of preparation will strike our mind, and we'll stick to that. Okay, without having like, even though we have two equally good statements. Okay, in this statement this is actually a little bit true to like more chance to be true, this statement, but then also if you have two equally good statement, go for the most true statement. Okay, like the more like qualifying statement, you go for that. So here government is responsible to the parliament and can be removed by it. That's the answer. Okay, and our Supreme Court also says that constitution is modeled on the parliamentary system and executive is having responsible to the legislature, and we have lots of measures where executive will be controlled by the like parliament or the legislature. Now the main advantage of parliamentary form of government is that in the parliamentary system executives are part of the legislature, and there are several mechanisms to make the executive more answerable and controlled by people's representatives. Next question, the parliament can make any law for the whole or any part of India for implementing international treaties with the consent of all states, with the consent of majority of states, with the consent of states concerned, without the consent of any state, without the consent of any state. Fine. If the President of India exercises his power as provided under Article 356 of the Constitution in respect of a particular state, then the powers of legislature of that state shall be exercisable by or under the authority of parliament. Is that true or false? How many for that statement? Okay, a few. Then the assembly of the state, I am not telling whether it is true or false, okay, we will discuss that. The assembly of the state is automatically dissolved. How many for that? Okay. Article 19 is suspended in that state. The president can make laws relating to that state. Okay, a few. So like what is the speciality of article, like what is the difference between the emergency, I mean national emergency under Article 352 and the president's rule under Article 356? See, president is an executive. Okay, president is an executive. Law will be made by the legislature. Okay, so by implementing the president's rule, the president may take all the authority of the executives in that state. Okay, whether it is governor or any other executive authority, but the law will be made by parliament. Okay, law will be made by the parliament. The powers of the legislature of state shall be exercised by or under the authority of the parliament. Okay, that's the thing. So the president can make laws relating to that state. That cannot happen. Okay, president will not be making laws. President is an executive authority. Now these two statements are easy. Okay. So when president's rule is imposed in a state under Article 356, president can assume to himself the functions of the state government, I mean executive, and the powers vested in the governor, again executive head, and any other executive authority in the state. Okay, clear. So this kind of confusion should be removed in the process of revision and your self-study as well. Now, which of the following, actually there is a pen mark here, don't misunderstand, this is the answer. Okay. Which of the following are not necessary, and you should mind these negations in the question, not necessarily the consequences of the proclamation of the president's rule in that state. How many for option A? Raise your hand with confidence, let it be wrong, no issues. How many for option B? Okay. How many for option C? How many for all of the above? I think a few people are operated by some battery and battery is not working. Like you don't have any answer, only a few people answered. So they are asking not the necessarily like consequence. Dissolution of state legislative assembly, will that happen like necessarily in a president's rule? Removal of council of ministers in that state, will that happen? Okay. Dissolution of local bodies, will that happen? Actually, technically, actually these options are designed in such a way that even though like you don't know the complete answer, like you can make it correct. The issue that I found with the people who said the statement option 2 was correct is that you answered with half knowledge. The answer is the same, okay, but you answered with half knowledge. In this question that got right, but this won't happen in every question, because when a president's rule is implemented in a state, the legislative assembly can be either suspended or dissolved. Okay, it is not both way. There are two choices. It can be either suspended or either dissolved. Here they say that actually dissolution of state assembly. Actually there is other chance also. They can frame the statement in a different way by telling it like a suspension. So during the president's rule the state executive is dismissed. That's the first action that will happen definitely. Then state legislature and local bodies are either suspended or dissolved. Okay, so that is one thing. So dissolution is not necessarily the consequence. Got it clear, right? Yeah. Consider following statements. The proclamation of national emergency is applicable to the entire country and not to any part of it. Second statement, the president can proclaim a national emergency only after receiving a written recommendation from the cabinet. Any doubt with statement 2? How many of you say that statement 2 is false? Can raise your hand. You may be right. Raise your hand with confidence, man. Okay, let it go wrong, no issues. Okay, a few people. So what about first statement? How many of you says that actually first statement is false? Okay. And second statement is true. How many? So what is the answer for you guys? 2 only. Okay. So this is actually a simple question. Okay, but some of you got confused actually. By the 42nd Constitutional Amendment Act, okay, it was decided that national emergency can be proclaimed to the entire nation or to some part of it. Okay, maybe only for Kerala they can proclaim the national emergency. It need not be president's rule. Okay, they can term it like national emergency and they can specifically say that it applies to Kerala. That happens. That can happen. So that statement is false. Then because of our Indira Gandhi's time, that issue, the 44th Constitutional Amendment made it clear that only after receiving written recommendation from the cabinet you can do this. I mean proclaim the national emergency. So this is the thing I have already explained. This 42nd Constitutional Amendment Act made it applicable to a specific part of India.